Okay, everyone. Last week, Don Lemon had a quiet week in court, but outside of court. Now, he went on The View to make his case directly to viewers, and this week as well, it was quiet for Lemon in court. Now, I'll talk about the new legal filings by his co-defendants later in the video, but this week, again, Lemon spoke publicly, this time at an event for a civil rights organization, National Action Network, founded by Al Sharpton, who now has a show on MSNBC or MS Now. So Reverend Al Sharpton is a mainstream media journalist now. Now here's Lemon speaking about his criminal case at the National Action Network.
Let me just say, my intention throughout this whole process was just to report. I went to Minneapolis to report, and that's my only intention. There was no conspiracy, there's no...
Okay, let me just stop the video there. Now, his intention in going to Minneapolis was just to report, he says, but his actions were very different from his intentions.
Any of it. To me, and to most people, most sane, rational people, these are cooked up charges to, I believe, embarrass, to really suppress journalism, to make journalists afraid and fearful, and to second and third guess themselves about telling the truth. And I think it's also to embarrass people. And I think it's racist. Because they're using laws that were meant for people who were truly oppressed, meaning African Americans who fought for civil rights in this country. They're using those same laws to prosecute and persecute African Americans. Look at the journalists who were arrested, black.
Well, a white journalist was arrested as well. Shane Bowman. Now, there he is on the right-hand side in the red jacket. Now, this photo shows him filming the attack on the church. Now, Bowman's lawyer emphasized in the filing that his client wasn't acting like Don Lemon because his client had his mouth closed. Now, in reference to the charges Lemon spoke about, he was indicted under the KKK Act because the conspiracy targeted people exercising their constitutional right, the right to worship freely. Now, the other charge on which he was indicted is under the FACE Act, often used against defendants who block entrances to abortion clinics, but it can be used against those who block access to churches. Now, here's more of Lemon.
But they're going after all journalists. Look at what's happening with the Washington Post, right? They are trying to, they had a search warrant, they searched her home, they have her phone, they have my cell phone, still now to this day. So.
Okay, so he was talking about Hannah Natanson, a Washington Post reporter who received classified information from an indicted leaker at the Pentagon about the Venezuela op. Now, the FBI raided her house pursuant to a valid search warrant and seized classified materials, okay? But according to Lemon, the reporter and the Washington Post are the victims, which is absurd. Now, journalists seem to feel they're entitled to classified information now. And Lemon mentioned his cell phone. Now, the DOJ's filter team is going through the cell phones. So any privileged information, such as confidential attorney-client communications, won't be disclosed to the prosecution team. Now, with that being said, there must be a treasure trove of evidence there in all of the cell phones. Every defendant's cell phone was seized, apparently. And maybe that explains... Now, this new filing this week, a large number of Don Lemon's co-defendants filed this petition for disclosure of grand jury materials, even though grand jury proceedings are supposed to be secret to protect the grand jurors and witnesses and the integrity of the process, protect them from outside influence and harassment. So, grand jury materials should not be disclosed except in very rare instances to prevent injustice. The defendant has to show a particularized need for the material and show that it cannot be obtained without extreme difficulty through other means. Now, several weeks ago, just after the arraignments, Don Lemon and his co-defendant, Georgia Fort, filed a similar motion in which they asked for the entire grand jury transcript. Now, the judge hasn't ruled yet. Now, my view on the requests for grand jury disclosures is that they make the defendants look desperate, okay? The defendants allege that the U.S. attorney could have committed misconduct before the grand jury, and Every criminal defendant who's ever been indicted says that. Now, months ago, when Don Lemon's cell phone was seized, I theorized that his motion for disclosure of the grand jury transcript was a bluff, essentially, and that Lemon's legal team was hoping there was misconduct in the grand jury proceeding because there's probably evidence of bad conduct on Lemon's cell phone. And maybe they're hoping the grand jury material will cancel out the bad conduct on Lemon's cell phone, so to speak. But in my view, that's not likely because these past several weeks, the U.S. attorney has been cool as a cucumber while the defendants have been sweating profusely. So I've seen no reason to change my theory about the contents of the discovery material in the U.S. attorney's possession. And do I, for a moment, suspect there was misconduct before the grand jury? No. The reason why the U.S. attorney went to the grand jury is because one of the federal circuit judges told the U.S. attorney, essentially, that the grand jury was an option. Okay, this was very early on in the case when the magistrate judge had refused to sign the arrest warrant for Don Lemon, and the government appealed to the Eighth Circuit, which said the complaint and affidavit clearly established probable cause for all 5 arrest warrants. Now, the circuit judge told the government, you haven't established that you have no other adequate means of obtaining the relief. So, boom, he's telling them, you can go to the grand jury. And strangely enough, the magistrate judge, or magistrate judges plural, who refused to sign the 5 arrest warrants initially, later began signing all of the other arrest warrants. So it seems the magistrate judges read the circuit judge's concurrence. So while the defendants are alleging all kinds of potential misconduct by the U.S. attorney, it seems the magistrate judges are proceeding on the view that they were in error to refuse to sign the initial arrest warrants. The defendants, though, are treating the errors by the magistrate judges like scripture. And I've said this before, motions practice isn't going well for the defendants. Every time the defense files a motion, it starts off with a paragraph that says the defendants were just participating in a peaceful protest. I mean, it's a cut and paste paragraph at the start of every motion, and it makes the defense look like liars because it's blatantly inconsistent with the video footage. Now here's Lemon again.
These are very serious charges. I think if they had their way, they'd like to put me in prison for just reporting. And so I love my friends in corporate media, and these folks are doing a fantastic job. The pressures are different for them, and I don't miss the pressures that you guys are under. So I don't have those pressures now in independent media because I can just say whatever I want. But then I don't have the support of a big network, right? A giant legal team behind you.
But saying whatever he wants is what got Don Lemon into trouble at City's church, saying and doing whatever he felt like. Now, he blurred the line between activist and journalist, especially in that his sympathies clearly were with his co-defendants. Now, for example, he confronted people at the door as they left the church, and he's Don Lemon. You know, he has the establishment veneer, which carries a lot of power in people's minds. Now, with all the screaming and shouting, churchgoers probably felt they had to speak with Lemon amid the looming threat of mayhem. Speaking of mayhem, Defendant William Kelly, a.k.a. Doe Oak Farmer. He just convinced the district judge to affirm the magistrate judge's decision to remove almost all of his release conditions. Now he just has to stay away from City's church and submit to a mental health assessment. Now, potentially, he could be found incompetent to stand trial or insane at the time of the offense, in which case, typically he would have to be hospitalized involuntarily until such time that his competence is restored and he can stand trial. Now, some defendants hate being hospitalized. They view it as incarceration, but some view it as a refuge from a cruel world. Regardless, because a criminal case is in process, Defendant Kelly won't be free of the system until the charges are resolved on the merits. And they will be when his competence is restored. If he's incompetent now, that is. The prosecution at some point will continue. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.